Thank you, Julie, and thank you to everyone for taking some time to come out and be with us this afternoon. I'm actually just having a little 2-second flashback of standing almost in this exact spot, but facing that direction. And it was wet. It was very wet. Not spilt water, perspiration. First year moot. My mooting partner, who shall remain nameless, had glowed so much that you could literally go down right at this very spot. Things have worked out really well for him. Things have worked out really well for me. And it's great to be back at Western again. So today, as Julie said, we're going to talk a little bit about class actions. And you guys can fill me in. Do you even have a class action course? Is that something that's available? Anybody here taken that? Okay, so knowing that then, just to start us off, I think it's important to emphasize that class actions are just like any other civil litigation. You still have to have a claim. You still have to have a cause of action. There's still going to be a defendant or defendants. There's no wild and wonderful magic to much of class action. But what is important to note is that before you get to be a class action in our jurisdiction, and actually in all jurisdictions in Canada, there has to be some level of court approval. So in Ontario, it's the Class Proceedings Act 1992, Section 5, and the courts, as some of the folks that were with us in Professor Costel's tort class this morning know, really comes down to preferable procedure. That's what the courts are looking for. And that term has been further broken down into 3 concepts. So the judge is going to be asking, in order to determine preferable procedure, whether you are providing access to justice that wouldn't otherwise be there. So generally speaking, that's a bunch of smaller claims that would not be practical or economical to litigate on an individual basis, but the court is seeing this as an opportunity to allow people to bring their claim, notwithstanding the fact that they wouldn't be able to do so individually. The second thing the court looks at is whether there's going to be judicial economy. Because if you've got hundreds or potentially thousands of individual claimants, it doesn't make a lot of sense to have hundreds or potentially thousands of judges tied up doing all those claims. And then the third thing is behavior modification. And there the court is asking, is there an opportunity to change the conduct, the behavior of not only the defendant or defendants that are actually involved in the case, but other similarly situated defendants. So that's the legal test. And there are other aspects to it. You have to have a litigation plan, a representative plaintiff, and so on and so forth. The other key thing to keep in mind is, unlike the Aaron Brockovich type movies where they're out there signing up plaintiffs, in our system, the representative plaintiff proposes the class and says, this is who we think should be our class, and the court either agrees or disagrees, but all those class members have essentially no involvement in that process or that decision. And they just wake up one morning and the court directs certain notice to go out, and you suddenly find, oh, I'm a class member. Now, if you don't like it, you can opt out, so you're not stuck as a class member, but the system's very different than what we see on particularly American television. So with that as a little bit of an overview, I'd like to talk first of all about the Inco case. That is the Inco refinery in Port Colborne, sometime circa around the time of the roughly 1930s is the best information we have. Very large facility relative to the size of the community. Community only, Port Colborne only has about 18,000 people in it even today, but at times the refinery employed up to 2,600 workers. The stack that you see on the right-hand side of the frame is about 500 feet tall. So for anyone who's read the decisions, as the courts have consistently recognized, everybody knew it was there. It wasn't a closely guarded secret or anything. In the year 2000, information started coming out about different substances that the Ontario Ministry of the Environment had done sampling and had found elevated levels of these substances. The most commonly detected was nickel. So the sampling was done in a campaign in 1998-99, and as you can see from the photograph, the Welland Canal is the blue line that kind of bisects the community, and the southern terminus of the Welland Canal at Lake Erie is the town of Port Colborne or city of Port Colborne, and just to the right of the canal, where you get into the green type colors, that's where the Inco refinery is located. That's also, as some of you may have, if you've read any of the decisions, heard about the Rodney Street area. The Rodney Street area is about a 10-block area that's been the most heavily impacted. The east side community, which is also referred to in the decisions, is the rest of the area on the east side of the canal, and then the west side is to the left on that particular chart. As you can see, they were predicting nickel levels of up to 4,000 to 5,000 micrograms per gram or parts per million, which is the unit of measurement that they use for those types of substances. The numbers that are directly below the colored sections of the legend, 43 micrograms per gram or parts per million, that line is the line, the 43 is important because that's the expected naturally occurring level of nickel in soil in the province of Ontario. So if we walked out of the front of the law school and took a sample, you could expect to find about 43 parts per million of nickel that just naturally occurs in our soils in this part of the world. The 200 parts per million or micrograms per gram, that at the time was the level that the Ontario government said was the trigger level for further investigation. So as long as you have less than 200 parts per million, you're not going to have any observable effects from nickel, and as a result, if you're below that, you don't have to do anything. If you're above that, that's when you start to have to deal with the MOE in various ways. This is some subsequent mapping that was done after our client, Ellen Smith, who is now the representative plaintiff, Wilf Pearson. The claim started Pearson versus Inco. Mr. Pearson is getting up there in years and just hasn't been able to continue. So literally his next door neighbor, Ellen Smith, is now the representative plaintiff. Well, Craig Edwards, he and Ellen share their home with their family, and they looked at that chart with all the funny colors on it and said, I live right there, what's my soil level? And the MOE said, we don't know. The only way to find out is to sample. So they did. And the samples were taken in June of 2000, and we ended up in the fall of 2000 with the results coming back. You can see the numbers are getting higher. And at this point, they're finding 11,000 parts per million of nickel or more. Bearing in mind that the trigger level to start to have some concern about nickel is 200. And they're finding more than 11,000. This is from a report that was released in 2001. And it may be a little hard to read, but fourth column from the right on the chart is the nickel levels. These are all coded identifiers for privacy reasons. But we have clients that, if you read the third number down, 16,000 parts per million in their front yard sample. So it has always been the plaintiff's position that it was the start of the disclosure of these unexpectedly high levels of nickel that caused, ultimately, real estate values to decline in the community. The Ontario government recognized that something wasn't right. And as a result, they issued an order requiring Inco to clean up properties that had more than 8,000 parts per million of nickel. So that's the actual order that was issued to Inco. How'd they come up with the 8,000? They commissioned a study. They did it internally, and then they had it peer reviewed by experts from the United States, from Europe, and so on. Bear in mind, all this is happening in this little city, 18,000 people at Port Colborne. So you've got people out sampling hundreds of properties. You have all kinds of information coming out into the public realm. You have cleanup orders being made. At least in the plaintiff's view, a lot of activity. The statement of claim, and that's the actual original statement of claim, was issued on March 26th, 2001. So 2001 to 2011, this claim has now been going on for more than 10 years since it was started. So anyone who says that, you know, class actions are a great get-rich-quick opportunity hasn't done one. So from that standpoint, ultimately, the claim went through various levels of court. So in order to get certified, we started at the Ontario Superior Court of Justice. And the Superior Court of Justice said, no, no. In fact, they didn't come up with one or two reasons. They came up with 18 reasons why the Inco claim should never be certified. So that caused us to have to rethink. By the way, I should sort of throw this in. Every firm that I've been working with since the claim started in 2001 has been a small firm. I think the most lawyers of any of them was 7, and some of them have been smaller than that. My current firm is myself, one other full-time lawyer, an articling student, a summer student, a legal assistant, and usually 1 to 3 lawyers that we're retaining on a project-by-project contract basis. So at most, 6, 7 lawyers working. You cannot take on this kind of litigation with the size of firm that we are and be effective. That's my honest belief. So whenever we get involved in these kinds of cases, we partner with other law firms. So as I was saying to a couple of other people, I now know why they made us work as law students with other lawyers, even though it may not be the most fun thing in the world sometimes, it's a very effective way to marshal your resources, and whether you're working with other lawyers within your own firm, or, as we have done, partnering with other law firms. So the Inco case, we have been partnered now for many years with Koski Minsky, who have a whole section that does nothing but class action type work. The G20 that we'll come to in a few minutes, we are partnered with Klippensteins. And Klippensteins is well known in the legal community for their work on police work, particularly the Ipperwash inquiries, representing the estate and family of Dudley George through many years of litigation and a judicial inquiry and so on. So basically, if we're going to do this kind of work, you're working with a team. So the team had to sit down and give their head a scratch or a shake and say, what are we doing? For anyone that's followed any of the class action jurisprudence, the first real indicator that we got from our Supreme Court about how class actions were going to get treated came in 2001. But in the fall of 2001, and our claim was launched in the spring. And it was a trilogy of 3 cases. The Rumley decision from BC, the Hollick decision from Ontario, and Dutton, Western Canadian Shopping Centres, which came from Saskatchewan. And all 3 of those were the first sort of kick at the can that we had seen from the Supreme Court about how they were going to deal with class actions. So we significantly modified the claim. And there was some talk about dropping causes of action, but when you do the chart and check off, well, how's that helping us with the 18 reasons we didn't get certified? It was only going to take care of about 6 of them. So I had suggested to our co-counsel that there was another approach, and that was to not proceed further with the health claims, because originally the class action had both property devaluation but also health. And ultimately it was the health claims that in our view was adding this huge amount of individuality, which is usually the hallmark of an action that's going to fail. That's what the Supreme Court has told us. So from that standpoint, it was time to do something pretty different, and we did. And we stopped proceeding with the health claims. Health is still being addressed in the community. It's not been forgotten, but it's being addressed through a different type of process. And it hasn't been litigated since all the way back in 2002 when we appealed to the divisional court and lost again. So, putting it simply, nobody went through the Inco case with any false illusions about this being an easy case or an easy, road to be on. That brought us to the Ontario Court of Appeal, and in November of 2005, the Court of Appeal reversed the earlier findings and said, yes, your claim is amenable to class action treatment, and certified the claim. So that decision, Inco sought leave to appeal to the Supreme Court of Canada, but in June of 2006, the Supreme Court of Canada said no leave to appeal. So as a result, certification was decided all the way back in 2006. And that was the end of the certification process. There's nowhere you can go after leave to appeal is denied by the Supreme Court. At the same time, this is all impacting on real people who are having, in their view, very significant problems. And it became very clear that property devaluation was the area that was going to be the area that was most suitable for class action treatment, group type assessment. And people started talking about the Inco case. And so far, I think the case has resulted in almost 50 reported decisions from all of the different things that have happened at different levels. And it's been cited now several hundred times in various contexts. So it's clearly a case that people have been watching, because the Hollick decision from 2001, many people said that's the end of environmental class actions. Because it was an environmental case related to the Keel Valley landfill, it was brought in nuisance, and ultimately they'd been successful in round 1. They'd gotten certified at the Superior Court level, then the Divisional Court reversed that, the Court of Appeal upheld the reversal, and ultimately the Supreme Court of Canada upheld the reversal. But at the same time, the Inco case has been viewed, and I think it's fair to say even today, is still being viewed as the new environmental standard bearer case on these kinds of issues. So, the case actually went to trial. That is not normal in class actions. And ultimately, the trial lasted, fortunately not continuously, but for I think a little over 7 weeks, between October of 2009 and January of 2010. And the decision was released on July the 6th, 2010. Decision, I actually looked at the picture of the author of that decision, which is hanging in the hallway upstairs. If you go and see the Honorable Justice Joseph Henderson was the trial judge in the matter, and he is an alumni as well here. So his decision came out in July of 2010. In terms of causes of action, he said there was no negligence. That was easy for him because we had discontinued the negligence claims. Negligence, in our view, was going to be too complex to litigate because the facility had operated from 1918 all the way up to 1984 as a nickel processing facility, where you're going to have all kinds of different standards of care and all kinds of different facts, and a 7-week trial was enough. It would have been a year-long trial if we had litigated on negligence. So that made His Honor's decision very simple on negligence. He did say no trespass, that those particles of nickel floating around and coming out and landing on people's lands did not amount to a trespass. I've had discussions with a number of different counsel in the environmental law area who have said, why didn't you appeal that? And that's probably a discussion for another day. All I can say is we did not. So that's why ultimately the Court of Appeal doesn't deal with trespass, because it wasn't part of the case by the time we got to the Court of Appeal. However, Justice Henderson did find liability on the basis of nuisance and liability on the basis of the doctrine of strict liability, Rylands and Fletcher. And he awarded $36 million in damages related to the devaluation of property. However, as we all know, in our legal system, that's rarely the end of the story, at least on larger cases. So off to the Court of Appeal. The hearing was from May the 9th to May the 12th of this year, and the decision came out just within the last couple of weeks on October the 7th. And the Court of Appeal has reversed all of the findings of the trial judge. So, no negligence, no trespass, no nuisance, no Rylands, and no damages. And they said that's because the MLS data, the multiple listing service data that was being relied on by the trial judge was unreliable, and the MPAC, or Municipal Property Assessment Corporation data, the taxation data, they said there are 314 vacant lots. If you spend any time reading this case, you'll find out all about the vacant lots. And because they keep moving from different classifications, sometimes they're classified as agricultural land because there's no houses on them. But sometimes they're classified as residential land because they are residential building lots. And if you start taking them and moving them, they're very low value properties, obviously, because nothing's been built on them. So it is reasonable to assume, and it is true, that if you move them into the residential property class, they will deflate the value because there are a bunch of lots being added in at very low value. So you put that into the average, it lowers the average. When you take them out and move them back to agricultural, well, of course, values pop up. And there is some connection between the MPAC global valuation for all the properties in Port Colborne and those properties moving in and out. There is a connection there. But the Court of Appeal said the connection is so great that it really explains everything, and as a result, no damages. So that's where we stand. What I can say just before we leave the Inco case is this: the decision was not a surprise. After you've sat for 4 days hearing the bench asking questions, and we had a very active bench for this particular hearing, it's not all that hard to figure out, how things are shaping up, just because of some of the exchanges and some of the dialogue. So nobody left the courtroom on May the 12th with, frankly, any illusions about the outcome at this particular level of court. At the same time, you always have to see the decision before you know, and now we know. But I can say two things that I think are important for anybody that would be thinking about getting involved in this type of work. First of all, this is not the first time this has happened. We were unsuccessful twice in certification, and ultimately the results still worked out fine. So there will definitely be a motion for leave to appeal, because you cannot go to the Supreme Court of Canada as of right automatically, except in a very limited number of cases, and ours isn't one of those cases. So we will need permission, leave to appeal to the Supreme Court. I can say that so far, the commentators that are commenting on this, and obviously it's good to listen to those people because they are viewing it in a different way than class counsel will be viewing it. Most of them believe that the case has raised enough interesting issues that there is a reasonable potential, and it's only a potential, but a reasonable potential that the Supreme Court of Canada would have some interest in the development of the law of nuisance and the development of the law of Rylands, and just generally in class actions. So this does not, this is not the final chapter. That'll be up ultimately one way or the other to the Supreme Court to decide A, whether they'll hear the case, and B, if they hear the case, how they will ultimately determine the case. But I can say the decision has already been made to seek leave to appeal. The materials are due on the 5th of December, and generally speaking, that process takes about 6 months, roughly, give or take, before you get the answer from the Supreme Court, so more to come. The second point I'll make is this. There's sort of two ways to do class actions, and both models have been tried and both are still operative even as we're standing here today. One is to do nothing but class actions, or a very high percentage of them. That can be a bit of a roller coaster experience. And I personally know class counsel who have owned a house, lost it, owned it, lost it, owned it, lost it, and now own it again. That's one way to do it, but it's a very, very challenging way. But there are firms out there that are based solely on doing nothing, they're class action specialty boutiques, and that's what they do. And so from that end of it, some of them have been very, very successful. But we made the decision a long time ago that we would not put all of our business eggs in that particular basket, because as probably most of you know, class actions are contingency fee based. You only get paid if you win. So from that standpoint, we have now litigated thousands of hours of time, spent very large amounts of money on disbursements, fortunately been helped by the Law Foundation through the Class Proceedings Committee in more recent years, but we had to start out on our own. We did all of that knowing that there was no guarantee of a positive outcome. You have no way of knowing that. So our business model has always operated on the premise that whether the case is successful or not, we're still going to be around and doing business. So on that basis, whatever the outcome of the case is, obviously we have an interest. More importantly, our class members have a very, very significant interest in the outcome of this case. But at the same time, we have always gone into it knowing that we would not know the outcome, because cases like this do tend to get litigated for long periods of time and end up at very high levels of court, and you just don't know. So from that end of it, I think it's fair to say that if anybody's thinking about potentially getting into some of this kind of work, it's worth asking yourself, do you want to put yourself in the we do class actions area, or do you want to put yourself in the area we're in, which is where we try to strike an appropriate balance between the class action work that we're doing and the other forms of civil litigation and administrative law, because we do a fair amount of both, as Julie mentioned, to be able to say, irrespective of the outcome of the Inco case or G20 or anything else that we've been involved in, and those are not the only two class actions, that we're still going to be in business and still continuing to practice law, irrespective of the actual outcome of any of these cases. So, turning to the G20. I think you'd be hard-pressed to find too many people, at least in Ontario, that haven't heard about the G20 events from last June. And activities started up on the 25th of June. And even on the Friday, there was lots going on in the streets of Toronto. I think it's fair to say that I would have no difficulty introducing you to people who have, they believe, legitimate claims for tortious conduct and charter violations on the Friday. But one of the key things to managing a class action is understanding how to make it manageable in the view of the court. So this particular class action is designed to try to be intentionally amenable to certification. And the conduct that we will be asking the court to review as part of that did not occur on the Friday. So there were lots of things going on, but things started to get lively on the Saturday. It was pretty clear, even before the events unfolded the way they did, that some people were expecting not a normal day at the protest parade. And from that standpoint, and we've said this many times, there is no doubt in the minds of our representative plaintiff and class counsel that the police services had a very important and significant role to play in managing the security of that event, and in many cases were doing their jobs properly. So the difficulty in our minds has been, how do you take police activity and police conduct that clearly was appropriate and necessary, because I don't think any of us, or at least most people, don't want to live in a society where the police cars are getting burned on a regular basis. That does happen in certain parts of the world, but that's not Canada. So I think there is a legitimate recognition on behalf of our plaintiff and most of our proposed class members, and certainly the law firms that are working on this claim, that the police had an important role in preserving public security, public order in the course of the G20. Smashing windows and making Molotov cocktails and burning police cars, that's what the police are there to deal with, and they have the powers to do that, and they were doing their job in many of those cases. But then how do you separate that out from some of the other things that happened? I think it's fair to say this is one of the most well-documented events in Canadian civil liberties history. We certainly don't claim we've got everything, but we have tens of thousands of photographs and thousands of hours of videos that have been submitted to us by putative proposed class members. And the kind of force that was used and the kinds of tactics that were used and some of the events that unfolded, there are many proposed class members who are quite prepared to testify to facts that we believe will support a proper legal claim to say some of the events that occurred are events that are, there's liability for and damages for. I think it's fair to say that of all of the activities that happened over the course of that weekend, the use of the so-called Kattiline tactic or strategy by the police was probably the most controversial. That's a tactic that has been used by police services in various parts of the world. And I think it is fair to say it is now very much falling into disuse. So there have been decisions in Canada previously about the use of Kattiline. There have been decisions in the United States, Washington, D.C., Seattle. There was a recent decision by the High Court in London, England, about the use of Kattiline as a strategy. And I think it's fair to say it's become quite problematic. And it's our understanding now that even the Toronto Police Services have said they will not be utilizing the Kattiline approach any further. But it clearly is something that created a lot of the issues that we believe can be resolved most efficiently through a class proceeding. The other area where, from the information that's been provided over the many months that it's been since, where there were significant issues was at the Eastern Avenue Detention Center. And that's where not all, but certainly the majority of people that were detained by the police were taken. And the events that occurred there, we believe, give a proper basis for a claim to be brought before a court. The claim was announced on August the 6th. That's a long time in the class action world. You know, June 25, 26, 27, when all the events were taking place, and here we are all the way off at August the 6th. And that's because I think it's fair to say the claim has some challenges to it, and it's also, relatively speaking in the class action world, not a high dollar claim. It's for $45 million, sounds like a lot of money, but when you actually break down the kind of damages that an individual would recover from these types of torts, using the Ward case as an example for the charter violation case from out in BC with the city of Vancouver, Mr. Ward was successful in getting damages for being improperly strip searched, but he got $5,000. That doesn't even generally warrant a small claims court action in this day and age. So that, I think, was a factor. It's also a very controversial area because, as we've said before, we respect the fact that many police officers were doing their job and doing their job properly. And somebody had to think about, well, how are we going to recognize that and respect that in crafting a class action? So our claim is, the purpose is to try to address the concerns of people who are either demonstrating or present just by chance or observing or reporting, who were arrested, detained, or imprisoned and held by the police. You'll notice the word charged is missing. So with a couple of exceptions, charged people don't fit our class. The plaintiff is Miss Sherry Good, and that means the claim is known as Good versus So, yeah, some other people filled in the blank differently than we're allowed to, but our blank gets filled in. Toronto Police Services Board, Attorney General of Canada on behalf of the RCMP and CSIS and so on, Ministry of the Attorney General, and Peel Police Services. The identification of the class, we think, was probably the most significant reason that the Good action was given carriage. There were two competing class actions, and I'll come to that in a little more detail in a moment. But our claim deals with people who were released without charge or imprisoned at the Eastern Avenue Detention Center. The problem with charged people is there is absolutely no doubt that there is strong evidence of people committing acts that would likely lead to conviction. And everybody who was, smashing in the windows on the cop cars and breaking the Starbucks windows and all of those kinds of activities, in our view, likely will be convicted. And the court isn't going to pay them compensatory damages if they're performing illegal acts. So we had to try to figure out some way to deal with that. And I think it is the thing that has been the most time that we've spent on the claim, is trying to get a mechanism to be able to address the claim, to respect the fact that there will be people who have legitimate actual claims who we're not going to be able to assist through a class action mechanism, because our concern is it would break down into literally hundreds of individual trials, because the police may well have had reasonable and probable grounds to charge somebody. And even if the charge was withdrawn, which many of them ultimately have been, and more possibly to follow, I suppose, that doesn't change the fact that there could have been reasonable and probable grounds for the charges in the first place. So we looked at people who had been detained but not charged, and then we looked at essentially what happened at the Eastern Avenue Detention Center. Because, as most of you know, irrespective of whether somebody is guilty of an offense and ultimately convicted, there are certain basic rights. The right to legal counsel, the right to know what you've been charged with, the right to reasonable treatment in terms of the facility you're being held in, food, medical attention, clothing, all those types of things. Many concerns have been raised by many people, including people who are charged and some of whom will probably be convicted. It doesn't change the fact that they have some fundamental rights that are protected in our legal system, irrespective of whether they have committed an offense. So this may be a little challenging to read at this font size, but in order to try to deal with this, all this slide really is setting out are the subclasses that we've set up. And the subclasses try to break all these people and all these events down into manageable things in a legal way. So there's the first bullet, the Queen and Spadina subclass, and the Esplanade down at the Novotel, and Eastern Avenue out in front of the detention center, not in the detention center, and Parkdale and the Queen's Park subclass. Those are all Kattiline events that we see commonality in, and we believe that we have a reasonable prospect of persuading a court that there was something in common about the way people were being treated. Similarly, we've now added a gymnasium subclass related to the mass detention, arrest, and charging of people that were at the U of T campus staying in a gymnasium. They'd come in primarily from Quebec. Their charges have all been withdrawn because there's no warrant to even be in the premises and no reasonable and probable grounds. So we again see commonality with them. And we have created a residual subclass to try to deal with other people, but we don't know, frankly, whether that one's going to work. And then finally, we have the Eastern Avenue situation. So, causes of action, the big red letter banner one is going to be false imprisonment, but assault and battery, conversion and trespass to chattels, because a lot of people's stuff was either taken and damaged or not returned. Abuse of public office is a possible tort in relation to the command structure, and negligence. The claim, or at least the events, resulted in 2 competing class actions being started. One by Miranda McQuaid and Mike Barber, the McQuaid/Barber claim, and one by Sherry Good, the Good action. So, from that standpoint, the court had to make a decision, and that's a carriage motion. They don't happen very often. There's only been a handful of them in Ontario in all the years that class actions have been going on since 1992. You can't really have 2 claims going at once over the same set of facts. A, judicial economy, it's not very efficient, and B, you have a very high risk of the courts making different findings on the same facts. So those are just a couple of reasons. Why was the Good claim chosen? Ultimately, we believe it was because our claim is being perceived by the court as more manageable. The other claim names as its class anyone that was detained anywhere in Toronto over the course of the weekend. That's possibly tens of thousands of people, because the police were stopping people on the street and saying, "Can I look in your backpack?" And the police were stopping people randomly and saying, "Can I see some ID?" And a lot of that stuff ain't right. You know, in our legal system, there still has to be reasonable and probable grounds for the police to even detain you to that extent. But how are you going to find those people, and how are you going to prove that the police didn't have reasonable grounds? And in our view, it was going to be a very difficult claim to manage. There are other reasons, but if you're curious about it, you can go to Quick Law, Canley, whatever, and find Justice Horkin's decision from August 26th, where she decides, in her view, that the Good action is the action that should proceed. So, putting it simply, we've got our work cut out for us in the Inco case. We've now got our work cut out for us in the G20. So that's the actual schedule. As you can see, there are many steps to litigating a case. But you know what? In just about any civil claim, you're going to see a schedule similar to this. And our rules of civil procedure are now asking parties to put together discovery plans that actually are not all that dissimilar to this. But as you can see, it's leading to a hearing about a year from now, October of 2012. And we believe that this is a workable, manageable time frame. The McQuaid-Barber action was trying to get a decision, well, at least a hearing in April. And I think that was another reason the court may have been more favorably inclined to the Good action, because having done this for a while now, it's not too hard to figure out about how long each step is going to take, particularly when you're dealing with defendants like the Government of Canada, the Government of Ontario, Toronto Police Services, Peel Services, and so on. They're all going to be represented by very competent, skilled counsel who are going to utilize all of the various tools that are available to defense counsel to defend their clients' interests, and that's exactly what they should be doing. So that's kind of the roadmap, the timetable. And speaking of time, this is probably a good time to hand things back over to either Julie or Heather for some questions.